Georgia Supreme Court case. And in that case, the city council member who voted, which my client did not vote, but voted on a public improvement, there was evidence in that case that his property value was going to go up from 10 to 20%. And there was no kind of a number like that in this case, if there was a number at all.
You said your client did not vote. Is that because he doesn't have voting powers, or did he just choose not to vote?
That's right, Your Honor. He doesn't have voting powers unless there's a tie.
Did he speak in council during the debate, or yes,
Your Honor. The citizens would come to city council and talk about the flooding issues that were going on out there, and they wanted them to be fixed. And while they were discussing those issues, he would discuss it and participate in the discussion. Yes, Your Honor. And I'd like to reserve my last minute and 25 seconds if I could. Thank you, Your Honor.
Thank you, sir. Good afternoon. Due to the large number of errors that were identified in the appellant's brief, I've tried to organize them a little bit into major headings. And the first one is one we've been talking about, and that's claims about Section 45 being unconstitutional. Appellant has enumerated two errors, error number 3 and 4, claiming that Section 45 of the City of Springfield Charter is unconstitutionally overbroad and void for vagueness. We believe that the appellant failed to preserve any as-applied constitutional challenges and has failed to secure a ruling on any applied challenges prior to the trial. Contrary to appellant's claim in his reply brief, the trial transcript does not show that he made any applied constitutional challenges when preliminary matters were discussed before the trial began. Instead, it expressly states that he was raising the issues that had been previously raised in his motions to dismiss, the substance of which were only facial challenges. Moreover, even if he did raise an as-applied challenge, he failed to secure a ruling on these challenges at trial. The trial court specifically said the court will stand by its previous rulings there and at this point, and that's in trial transcript page 27. The trial court interpreted these challenges to be the same as those that were raised in the motions to dismiss, and appellant did not in any way indicate that he was raising a new as-applied challenge. In William Webster Shields versus the State, 269 Georgia 177, this court held that where a defendant failed to secure a ruling on his motion to dismiss in an indictment before announcing ready for trial, the issues as to whether the indictment should have been dismissed is not preserved for review. In Horton versus the City of St. Augustine, 272 F3D 1318, the court found that where conduct and not merely speech is involved, the overbreadth of a statute must not only be real, but substantial as well, judged in the relation to the statute's plain legitimate sweep. Appellant has failed to show the infringement. Appellant did not in any way indicate to the court that he was raising a new as-applied issue for the court to rule on that went beyond the original facial challenges, nor did he secure a ruling from the court on any new issues presented. This court has also held in Payne versus Bradford, 231 Georgia 487, that before a statute can be attacked by anyone on a ground of unconstitutionality, he must show that its enforcement is an infringement on his right of person and property. Based on the record, it is clear that the appellant did not show through any as-applied constitutional challenges at the trial level, nor did he secure rulings thereon. Thus, the errors were not preserved.
Let me ask you this about the appeal he had to the Superior Court. Did you list the particular charges other than he simply violated Section 45?
In the original petition?
The one to the Superior Court?
The petition to the Superior Court, yes, sir.
What did you list as violations?
The only thing that was listed in the original petition was that he, under the Section 45 portion of the charter, he was requested to resign based on the city council making a determination that he had done something in accordance, in violation of Section 45. So the only thing that was listed actually in the petition was it stated it stated the charter section. It stated that he was asked to resign at a city council meeting and that he had refused, and that this petition was being brought in accord with Section 45, requesting his resignation and asking the Superior Court judge to hear the case.
All right, well, what was he called upon to defend himself against, other than he failed to resign?
The issues were that, and you have to look at the whole process. The basic process is there was an ethics complaint filed that went to an ethics committee. The ethics committee had the opportunity to look at the different issues that were listed, and they made a determination that they didn't see anything wrong. The problem is, under the Ethics Code section 2-270, the ethics complaint then goes to the city council. And the city council actually makes the final determination as to whether or not there was any ethics violations done. There was a meeting, a city council meeting that was held. The city council went into an executive session. They discussed the ethics issues, and when they came out of executive session, they actually took action based on what was discussed in the executive session, and they requested at that point for the mayor to resign. The section 45 gives him 5 days to either resign, or they have the opportunity and actually the duty under section 45 to request that he, through a petition to the Superior Court, that the case be heard and that any evidence can be brought and the judge make the final decision.
Well, that's my concern. It seems as if ethics charges were brought against him. He was exonerated. City council then determined that charges would be brought and it would go to the Superior Court. And he was called to defend himself on the grounds that he refused to resign. Yet he had been exonerated of his ethics charge.
Well, actually, he had not been exonerated. The Ethics Committee actually found that the evidence or lack of evidence did not support the charges in the complaint. But the problem is that it's a two-step process. Once the Ethics Committee can make a recommendation, they make a recommendation to the City Council. In this case, there was no hearing. There was no evidence gathered by the Ethics Committee. Actually, the defendant really refused to participate in any investigation that was going on. At some point, his attorney did write a statement to the Ethics Committee that is in the record. But it's actually a two-step process. And the second step was that it came before the City Council, and they were the actual final decision makers whether or not to go forward with anything that came out of the ethics complaint. So it's really a two-step process, and the second step was where the City Councilman requested his resignation because they felt that what came out of the Ethics Committee was something that they needed to ask him to resign over. That he
now,
did.
what can your defense be if you're called upon to defend yourself, and you're called upon to defend yourself against the charge that you failed to resign? Either you resigned or didn't resign. That's the only thing you can defend yourself on, isn't it?
And that's basically what the petition said, that he failed to resign. So that was, the notice to him was that he had failed to resign in accordance with Section 45, and that in accordance with Section 45, they were going to the Superior Court, and to allow the judge in Superior Court to make a final decision as to what the charges were that came out of the Ethics Committee and whether or not he should be removed from office.
So the issue is not whether he resigned or didn't resign. It's the issue is whether he violated any of those enumerated items.
Yes, Justice, that's correct.
So is it, at some point in the process, is there anything that formally told the mayor what specifically he was being accused of violating?
The ethics complaint itself, which he had a copy of, listed and identified all the issues that were alleged to have occurred as an ethics violation. And he did receive that, and he actually replied to that.
Replied to it. in the Superior Court proceeding?
No, he replied to it in the Ethics Committee. He replied to the Ethics Committee.
How did he know, for example, whether it was one of the things in the Ethics Committee complaint, or all of them, or some of them, or those plus some other things?
Well, the list actually was in the ethics complaint, and he enumerated them in his response. He evidently understood what they were because he enumerated them in his response to the Ethics Committee.
What about in Superior Court?
In Superior Court, all we did was we said that based on the him not resigning out of the Ethics Committee case, then we just took it forward to have a judge make the final decision.
On what? On what specific issues? And how did he know which of the issues in the ethics complaint were now in the Superior Court?
It was based on the ethics complaint that came back to the City Council, and the City Council had all of the issues there in front of them. And when they asked for his resignation after this at the City Council meeting, it was based on the information that came out of the Ethics Committee.
When they asked for his resignation, did they say it's based on all of the things in the ethics complaint, or some, or?
Actually, we don't know that because that issue was, it was in an executive session, and there's no minutes or there's no, nothing kept for the executive session. So all we know is that when it came out of executive session, one of the actions that were taken was to ask for his resignation based on the discussions that took place in the executive session.
And in the discovery and everything else that led up to the Superior Court trial, was it ever clarified exactly which charges?
Part of the issue is that when his first motion to dismiss, he told the judge that he did not have actual notice of the issues against him. In Demescal, the Court of Appeals ruled that upon reading a complaint, if the defendant is uncertain of the nature of the claim, which he's been put on notice, the proper remedy for seeking particularly more information is by a motion for a definite statement. When they had the motion to dismiss, this issue came up, and Mr. Kicklighter offered to provide a more definite statement at that point, or the other option is it can be done by rules of discovery thereafter. There was a discovery period that the judge set down for 45 days, and during this period there were depositions taken. Actually, the defendant filed a counterclaim against all the individuals. There was motions heard. We went through the entire civil practice procedure before we got to trial. There was even a pre-trial order that was done and that the defendant participated in.
Let me ask you more specifically about some of the allegations itself. Open meetings violation, open records violations. I'm not aware of anything that prohibits somebody from disclosing information that's contained in executive session. Is there an express provision that makes that illegal?
There is a OCGA that the judge quoted in his...
And I don't see it anywhere in that code section.
It's my understanding that also in the ethics code section that a city councilman or a public official has the duty to protect confidential city information from outside sources.
There's nothing